Question 1. During a critical transition period where existing processes for maritime liens enforcement are under review, a dispute arises between a shipowner and a salvage company regarding the priority of their claims. The ship is subject to multiple liens, including a preferred ship mortgage, crew wage claims, and a salvage claim. The shipowner argues that the mortgage takes precedence, while the salvage company asserts that their claim should be priority based on Admiralty Law principles. Which claim is most likely to be ranked highest in priority? A. The preferred ship mortgage, as it is recorded and secured under U.S. law. B. The salvage claim, as salvage services contribute to the preservation of the vessel. C. The crew wage claims, as they are essential for maintaining operations. D. The shipowner's right to possession, as they hold legal title to the vessel. Why D is incorrect. A shipowner's right to possession does not supersede valid maritime liens. The shipowner may still lose the vessel if higher-ranked liens are enforced. Question 2. In a situation where formal requirements conflict with international maritime pollution regulations, a vessel operating in U.S. territorial waters is found to have discharged oil in violation of MARPOL and the U.S. Oil Pollution Act of 1990. The vessel's operator claims that their discharge was in compliance with the laws of their flag state and seeks to challenge the penalties imposed by U.S. authorities. Under Admiralty Law, what is the most legally sound principle that applies to this case? A. The flag state's regulations always take precedence over local laws. B. The vessel is only subject to enforcement actions if pollution reaches another country's waters. C. The coastal state U.S. has jurisdiction over environmental violations within its territorial waters. D. The MARPOL Convention does not apply to foreign-flagged vessels operating in domestic waters. Answer. C. The coastal state U.S. has jurisdiction over environmental violations within its territorial waters. Explanation. Under UNCLOS United Nations Convention on the Law of the Sea and MARPOL International Convention for the Prevention of Pollution from Ships, coastal states have sovereign jurisdiction over environmental violations occurring within their territorial waters up to 12 nautical miles from shore. The Oil Pollution Act of 1990, Open 90, establishes that foreign-flagged vessels in U.S. waters are subject to U.S. environmental laws. Why? Is incorrect. While flag states have regulatory control over their vessels, coastal states retain jurisdiction over environmental laws in their waters and close Article 220. YB is incorrect. Pollution enforcement is not limited to transboundary cases. The MARPOL allows states to regulate discharges in their jurisdiction. YD is incorrect. MARPOL applies to all vessels, in foreign-flagged ships, when they operate within a coastal state's jurisdiction. Answer A. The arbitration clause should be enforced as per the New York Convention. Explanation: the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, 1958, requires courts in contracting states, including the U.S., to uphold valid arbitration agreements in international contracts. Since the parties agreed to arbitration under ELMA rules, the court should dismiss the case in favor of arbitration. YB is incorrect. The ship's presence in U.S. port does not override an agreed arbitration clause. Federal courts generally defer to arbitration in international maritime disputes. See Mitsubishi Motors v. Solar Chrysler Plymouth, 1985. YC is incorrect. The ship owner cannot disregard binding arbitration clause simply by filing in court. Courts regularly compel arbitration in such cases. YD is incorrect. The charterer does not need to separately agree to arbitration if valid arbitration clause is already in place. The contract itself binds both parties. Question 4. During a critical transition period where existing processes are being reevaluated, a vessel owner is attempting to limit liability for a collision that resulted in significant environmental damage. The owner argues that they should be entitled to invoke the Limitation of Liability Act of 1851, claiming the accident occurred without their privity or knowledge. However, evidence suggests that the vessel's unseaworthy condition was known to the owner and safety protocols were inadequately enforced. In such case, how would court likely rule regarding the limitation of liability? A. The court will grant limitation of liability because the owner was not directly involved in the collision. B. The court will deny limitation of liability if the owner's negligence or privity in maintaining an unseaworthy vessel is proven. C. The court will dismiss the claim outright since environmental damage claims are never subject to limitation of liability. D. The court will allow limitation of liability only if the crew members were responsible for the accident. Answer: B. The court will deny limitation of liability if the owner's negligence or privity in maintaining an unseaworthy vessel is proven. Explanation: the Limitation of Liability Act of 1851 allows a ship owner to limit liability for certain claims if they can prove that the loss occurred without their privity or knowledge. However, courts have consistently ruled that if an owner had knowledge of unseaworthy conditions or failed to ensure proper safety, they are not entitled to limitation. In cases like in Re Hercules Carriers Inc., courts have denied limitation where ship owners failed to maintain seaworthiness. Additionally, environmental claims, particularly oil spills, are often subject to strict liability under laws such as the Oil Pollution Act of 1990, over 90, further reducing the chances of limitation. Question 5. When developing a solution that must address opposing needs in a salvage operation, a dispute arises between the ship owner and the salvors over the amount of the salvage award. The salvors argue that their efforts were exceptional and saved both lives and cargo, while the ship owner contends that the services provided were not extraordinary and that the standard, the no cure no pay principle, should apply. Under the Salvage Convention 1989, which factors will most likely influence the court's determination of the salvage award? A. The financial status of the ship owner and whether they can afford to pay the award. B. The severity of the peril, degree of success, and efforts of the salvors in preventing environmental damage. C. The personal relationships between the ship owner and the salvors, as well as industry norms. D. The original contract terms between the ship owner and the salvors, regardless of circumstances. Answer: B. The severity of the peril, degree of success, and efforts of the salvors in preventing environmental damage. Explanation: the Salvage Convention 1989 outlines key factors in determining salvage awards, including the level of danger to the ship and cargo. The more severe the peril, the greater the salvage award. The skill and effort of the salvors. Exceptional salvage efforts warrant higher compensation. The degree of success: if a ship, cargo are fully saved, the award increases. Environmental considerations. Preventing oil spills or environmental harm can justify additional rewards under Article 13 of the Salvage Convention 1989. The no cure no pay rule applies only when salvage is unsuccessful. However, in cases involving environmental threats, salvors may still claim an award under Article 14 even if they do not fully save the ship or cargo. Question 6. In a situation where formal requirements conflict with practical realities, a dispute arises regarding the enforceability of a maritime lien on a foreign-flagged vessel that has changed ownership. The original supplier of fuel and maintenance services asserts a lien under U.S. law, but the new owner argues that their purchase was free and clear of any encumbrances, citing the laws of the vessel's home country, which do not recognize maritime liens for such services. How will U.S. court likely decide? A. The U.S. court will enforce the lien if the services were provided within U.S. jurisdiction and the lien meets statutory requirements. B. The U.S. court will automatically dismiss the lien, deferring to the laws of the vessel's home country. C. The court will require the supplier to first litigate the lien in the vessel's home country before it can be enforced in the U.S. D. The court will only enforce the lien if the previous owner failed to disclose its existence before selling the vessel. Answer A. The U.S. court will enforce the lien if the services were provided within U.S. jurisdiction and the lien meets statutory requirements. Explanation. Under U.S. maritime law, specifically the Commercial Instruments and Maritime Liens Act, similar maritime lien arises when necessaries, such as fuel, repairs, and supplies, are provided to a vessel. These liens follow the vessel even if ownership changes. U.S. courts often apply the law of the forum U.S. law rather than the law of the vessel's home country when enforcing liens within U.S. Jurisdiction. Case law such as Gulf Trading and Transport Company v. Tento confirms that U.S. courts enforce liens even if foreign law does not recognize them, provided the services were rendered within the U.S. and met statutory criteria. Question 7. During an emergency response where multiple areas are impacted by an oil spill, a ship owner seeks to limit liability under the International Convention on Civil Liability for Oil Pollution Damage (CLC). The government, however, argues that the limitation should not apply due to gross negligence in the vessel's maintenance and navigation. Which of the following factors would most likely lead to the denial of limitation of liability under CLC? A. If the pollution resulted from natural disaster beyond the control of the shipowner. B. If the shipowner's conduct constitutes recklessness and knowledge that the pollution would likely result. C. If the government failed to take emergency measures to prevent pollution from spreading. D. If the shipowner immediately cooperated with authorities to contain the damage. Answer B. If the shipowner's conduct constitutes recklessness and knowledge that the pollution would likely result. Explanation. Under Article V of the CLC, shipowner can limit liability unless the pollution resulted from personal act or omission committed with the intent to cause damage, or recklessly and with knowledge that such damage would probably result. If the shipowner ignored known risks, e.g. failed to maintain the ship's hull or disregarded protocols, limitation can be denied. Similar interpretation was upheld in the Erica case, where limitation was denied due to the shipowner's reckless disregard for maintenance obligations, contributing to the spill. Question 8. During a critical transition period where existing processes are being reevaluated, a maritime lien dispute arises involving a supplier of ship repairs. The vessel in question was arrested in a U.S. port, but the shipowner argues that the repair contract contained a choice of law clause favoring a foreign jurisdiction where maritime liens for repairs are not recognized. Under U.S. law, how would a court likely determine the validity of the lien? A. The court will enforce the lien if the repairs were provided within U.S. jurisdiction, regardless of the choice of law clause. B. The court will automatically defer to the foreign law specified in the contract and dismiss the lien. C. The court will require the supplier to prove that the shipowner consented to U.S. law before enforcing the lien. D. The court will enforce the lien only if the ship was flagged under a U.S. registry at the time of arrest. Answer A. The court will enforce the lien if the repairs were provided within U.S. jurisdiction, regardless of the choice of law clause. Explanation. Under the Commercial Instruments and Maritime Liens Act, similar in the U.S., maritime liens attach to a vessel regardless of contractual choice of law provisions if the necessaries, such as repairs, supplies, or fuel, were provided in a U. Question 9. When developing a solution that must address opposing needs in a cargo damage dispute, a shipper claims that a carrier breached its duty under the Carriage of Goods by Sea Act (LawConquer) by failing to properly secure a refrigerated cargo shipment. The carrier, however, argues that the damage was due to an act of God and should be exempt under LawConquer's defenses. What must the shipper prove to hold the carrier liable? A. That the carrier was negligent in maintaining refrigeration equipment and failed to exercise due diligence. B. That the cargo damage was unforeseeable and occurred due to extraordinary weather conditions. C. That the damage would have occurred regardless of the carrier's actions or inactions. D. That the shipper improperly packaged the cargo, making the claim unenforceable. Answer: A. That the carrier was negligent in maintaining refrigeration equipment and failed to exercise due diligence. Explanation: COGS establishes carrier liability for damage to goods unless an exception applies, such as acts of God or perils of the sea. However, to avoid liability, a carrier must first prove it exercised due diligence in making the ship seaworthy and ensuring proper care of cargo. In the TL Jefferson case, a carrier failed to maintain refrigeration equipment, leading to cargo spoilage. The court ruled that the act of God defense was inapplicable because proper maintenance could have prevented the failure. Thus, the burden of proof shifts to the shipper only if the carrier proves due diligence. Question 10. In a situation where formal requirements conflict with practical realities, a ship owner files a general average claim after voluntarily jettisoning cargo to save a vessel during an emergency. However, one cargo owner refuses to contribute, arguing that the sacrifice was unnecessary. What legal principle will determine whether the ship owner's claim is valid? A. The principle of no cure no pay under salvage law. B. The LawConquer rules, which govern general average contributions. C. The ship owner's insurance policy terms, which dictate payment conditions. D. The Hague-Visby rules, which limit liability for lost cargo. Answer: B. The LawConquer rules, which govern general average contributions. Explanation: general average is a principle where all parties in a maritime venture proportionally share losses resulting from voluntary sacrifices to save a voyage. The LawConquer rules provide the legal framework for determining contributions. A key case, Birkdale Steamship Company v. Walker, established that cargo owners must contribute if the sacrifice reasonably made in good faith to preserve the ship and remaining cargo. Courts generally defer to the ship owner's judgment unless clear evidence shows the action was unnecessary. Question 11. During an emergency response where multiple areas are impacted by an oil spill, a dispute arises regarding a ship owner's liability under the Oil Pollution Act of 1990, OPA 90. The ship owner argues that their liability should be limited due to compliance with international pollution prevention standards. What key factor will determine whether limitation applies? A. Whether the pollution resulted from an unavoidable mechanical failure. B. Whether the ship owner exercised due diligence to prevent pollution. C. Whether the spill originated in U.S. port or international waters. D. Whether the government took adequate steps to mitigate the spill's impact. Answer: B. Whether the ship owner exercised due diligence to prevent pollution. Explanation: under OPA 90, a ship owner is strictly liable for oil spills unless they can prove that the incident was caused solely by an act of God, an act of war, or the negligence of a third party. However, if the ship owner failed to implement proper spill prevention measures or ignored safety protocols, limitation will be denied. This was established in United States v. Citgo Petroleum Corp., where Citgo was held liable despite arguing compliance with international standards. Question 12. When developing a solution that must address opposing needs in an international shipping contract, a dispute arises over a deviation from the agreed route. The carrier claims that the deviation was necessary for safety reasons, while the cargo owner argues it was an unjustifiable breach of contract. Under maritime law, how will the court determine whether the deviation was lawful? A. By assessing whether the deviation was made in good faith to avoid danger or protect cargo. B. By considering whether the deviation resulted in increased profits for the carrier. C. By determining whether the cargo owner explicitly authorized the deviation in writing. D. By applying the no cure no pay rule from salvage law. Answer: A. By assessing whether the deviation was made in good faith to avoid danger or protect cargo. Explanation: a deviation is a departure from the agreed voyage route. Under the doctrine of reasonable deviation, a carrier may lawfully deviate if the action is taken in good faith to avoid hazards, ensure cargo safety, or respond to distress signals. In Stagline Limited v. Foscolo, Mango and Company, the court ruled that deviations for safety reasons do not constitute breaches unless made for the carrier's commercial gain. However, unnecessary or reckless deviations may void liability limitations under COGSA. Question 13. During a critical transition period where existing processes are being reevaluated, a dispute arises over a charter party agreement between a ship owner and a charterer. The ship owner argues that a force majeure event relieves them of liability for failing to deliver the vessel as scheduled. However, the charterer contends that the delay was foreseeable and should not excuse non-performance. What factors will the court consider? Determining the applicability of force majeure. A. Whether the force majeure clause explicitly covers the specific event causing the delay. B. Whether the ship owner notified the charterer within 24 hours of the event occurring. C. Whether the ship owner's insurance policy covers delays caused by force majeure. D. Whether the charterer suffered financial losses due to the delay. Answer: A. Whether the force majeure clause explicitly covers the specific event causing the delay. Explanation: force majeure clauses in charter party agreements excuse non-performance only if the event is expressly covered in the contract and is truly beyond the control of the affected party. Courts examine the specific language of the force majeure clause, e.g. whether it includes natural disasters, political instability, or labor strikes, whether the event was foreseeable and preventable, whether the ship owner took reasonable steps to mitigate the delay's impact. In Ocean Tramp Tankers Corp. v. Vosofrat, the Eugenia case, the court ruled that foreseeable political risks did not qualify as force majeure because the party could have anticipated and avoided the issue. Question 14. When developing a solution that must address opposing needs in a vessel collision case, a ship owner argues that they should not be held liable because the other vessel's captain failed to follow navigational rules. However, the opposing party claims that both vessels share fault under the principle of comparative negligence. What legal standard will determine liability? A. The rule of the road under the International Regulations for Preventing Collisions at Sea, COREGS. B. The last clear chance doctrine, which places full liability on the last negligent party. C. The principle of absolute liability, which holds ship owners responsible regardless of fault. D. The no-fault rule, which requires each party to cover its own damages. Answer: A. The rule of the road under the International Regulations for Preventing Collisions at Sea, COREGS. Explanation: COREGS establish internationally recognized navigational rules for determining liability in collisions. Courts assess whether each vessel followed proper right-of-way, speed, and lookout rules, the degree of fault for each vessel, e.g. failure to yield, excessive speed, comparative negligence, meaning liability is apportioned based on percentage of fault. In the Pennsylvania case, 1873, the U.S. Supreme Court held that if a vessel violates a navigational rule, it must prove the violation did not contribute to the collision, strict burden that often leads to shared liability. Question 15. In a situation where formal requirements conflict with practical realities, a maritime insurer denies coverage for a ship owner's claim, arguing that the loss was caused by an excluded peril. However, the ship owner asserts that the proximate cause of the loss was an insured risk. How will court determine whether the insurer must pay? A. By applying the doctrine of proximate cause, which identifies the dominant cause of the loss. B. By reviewing whether the ship owner promptly filed claim within 30 days. C. By assessing whether the policy explicitly excludes negligence as covered peril. D. By considering whether the ship was registered in high-risk jurisdiction. Answer: A. By applying the doctrine of proximate cause, which identifies the dominant cause of the loss. Explanation: under marine insurance law, coverage depends on proximate cause, meaning the most dominant and effective cause of the loss. Courts evaluate whether the insured peril set in motion a chain of events leading to the loss, whether an excluded peril was merely an incidental factor rather than the primary cause. In Leyland Shipping Company v. Union, the court ruled that if an insured peril, e.g. a storm, causes damage leading to an excluded peril, e.g. war loss, the insurer may still be liable if the storm was the dominant cause. Question 16. When assessing risk in a multimodal transport contract, a cargo owner files a claim for damage that occurred during the inland trucking portion of a shipment under a through bill of lading. The carrier argues that the Hague-Visby rules do not apply to inland transport. What legal principle will determine the carrier's liability? A. The network liability system, which applies different rules based on where the damage occurred. B. The Himalaya clause, which extends liability protections to subcontractors. C. The doctrine of fundamental breach, which voids liability limitations for gross negligence. D. The seaworthiness doctrine, which assesses whether the ship was fit for its intended voyage. Answer: A. The network liability system, which applies different rules based on where the damage occurred. Explanation: under multimodal transport, liability is determined by the specific mode of transport where the damage occurred. If the damage happened at sea, the Hague-Visby rules apply. If the damage occurred during inland trucking or rail transport, domestic laws or the CMR Convention for European transport apply. In Kyokuyo Unlimited v. 8p. Molemask, the court ruled that the carrier's liability depended on the applicable inland transport law, not maritime conventions. Question 17. During an emergency response where multiple areas are impacted by a cargo spill, a dispute arises regarding whether a ship owner can limit liability under the Limitation of Liability Act. The cargo owners argue that the ship owner's negligence bars limitation. What must the ship owner prove to successfully limit liability? A. That the ship owner lacked privity or knowledge of the negligent act. B. That the accident was caused by an unavoidable force majeure event. C. That the ship was carrying hazardous cargo at the time of the spill. D. That the cargo owners failed to declare the full value of the goods. Answer: A. That the ship owner lacked privity or knowledge of the negligent act. Explanation: the Limitation of Liability Act 46 U.S.C. SS 30501 30512 allows ship owner to limit liability to the post-casualty value of the vessel unless they had privity or knowledge of the negligent act leading to the accident. Key case in Re Hercules Carriers Inc. confirmed that if negligence occurs at the managerial level, limitation is denied. However, if the negligence was solely due to crew members' error, the ship owner may limit liability. Question 19. When developing a solution that must address opposing needs in a maritime insurance claim, an underwriter denies coverage for cargo damage, arguing that the loss was caused by an inherent defect in the goods rather than an external peril. How will the principle of inherent vice affect the insurer's liability? A. It will exempt the insurer from liability if the damage resulted from the cargo's natural deterioration. B. It will hold the insurer liable for any damage occurring during transit, regardless of cause. C. It will require the shipper to prove the goods were in perfect condition at departure. D. It will allow the insurer to recover costs from the shipping carrier. Answer: A. It will exempt the insurer from liability if the damage resulted from the cargo's natural deterioration. Explanation: the doctrine of inherent vice excludes insurance coverage when cargo deteriorates due to its own nature rather than an external cause like bad weather or collision. If perishable goods spoil due to improper refrigeration, insurers may be liable if refrigeration failure is covered. If the goods naturally deteriorate over time without any external cause, insurers are not responsible. In UGAH v. White, the court ruled that cargo damage due to the oil's natural oxidation process was not covered under marine insurance policies. Answer A. The tackle rule, which limits carrier liability to the period between loading and discharge. Explanation. Under the Hague-Visby rules, a carrier's liability begins when the goods are loaded onto the ship and ends when they are discharged. If damage occurs before loading or after discharge, the carrier is not liable under Hague-Visby but may be under port storage rules. In Pyren Ompanelid v. Sindia Navigation Ompanelidi, the ruled that damage occurring before lifting cargo onto the ship was outside the Hague ruled scope. Question 21. During an emergency response where multiple areas are impacted by a vessel's grounding, environmental authorities claim that the ship owner is strictly liable for oil pollution under MARPOL regulations. The ship owner argues that liability should be limited due to an unforeseen technical failure. What will determine the ship owner's liability? A. The polluter pays principle, holding the ship owner accountable for pollution costs. B. The doctrine of proximate cause, determining the main factor behind the spill. C. The seaworthiness doctrine, assessing whether the vessel was properly maintained. D. The common carrier rule, obligating the ship owner to transport goods safely. Answer A. The polluter pays principle, holding the ship owner accountable for pollution costs. Explanation. Under the International Convention on Civil Liability for Oil Pollution Damage, CLC 1992, and MARPOL, ship owners are strictly liable for pollution damage caused by oil spills, regardless of fault, unless they can prove the damage resulted from an act of war, sabotage, or third-party negligence. The spill was entirely government negligence. In Erica oil spill 2008, courts ruled that Total S.A. was liable despite claiming the vessel's failure was unforeseen. Question 22. When assessing risk in a multimodal transport contract, a cargo owner disputes a carrier's attempt to apply Himalaya clause to shield subcontractors from liability. The cargo owner argues that the subcontractor was not party to the original contract. What principle will the court apply? A. The third-party beneficiary doctrine, determining whether subcontractors are protected. B. A doctrine of general average, requiring shared loss contributions. C. The unseaworthiness rule, assessing whether the vessel was fit for service. D. The forum selection clause, deciding where disputes must be litigated. Answer A. The third-party beneficiary doctrine, determining whether subcontractors are protected. Explanation. The Himalaya clause extends carrier protections to third-party subcontractors, but courts apply the third-party beneficiary doctrine to determine its validity. If the contract explicitly includes subcontractors, they are protected. If the wording is vague or ambiguous, courts may rule against the subcontractor. In Scrutton's Limited v. Midland Litti, the court held that stevedores could not claim liability protection without explicit inclusion in the contract. Question 23. During a period of technological advancement when new maritime security threats emerge, a ship owner refuses to comply with ISP's code security measures, claiming they are unnecessary for small vessels. Port authorities insist that compliance is mandatory. What legal framework governs this issue? A. The International Ship and Port Facility Security ISPs Code under Solus. B. The Hague-Visby rules setting liability limits for carriers. C. The Jones Act governing seafarer injury claims. D. The doctrine of unseaworthiness ensuring vessels are fit for service. Answer A. The International Ship and Port Facility Security ISPs Code under Solus. Explanation. The ISPs Code, part of SOLAS Safety of Life at Sea Convention, mandates security measures for all vessels over 500 gross tons engaged in international trade. Compliance includes ship security plans, crew training, and threat assessments. Failure to comply can result in detention or denial of port entry in U.S. v. Costco Busan, 2007. Failure to follow security and safety protocols led to criminal penalties after an oil spill incident. Question 24. During a complex maritime dispute involving multiple stakeholders, a vessel owner claims limitation of liability under the 1976 Convention on Limitation of Liability for Maritime Claims (LMC). However, a cargo owner argues that the ship owner's negligence was reckless and intentional, making limitation inapplicable. How will the court determine whether limitation of liability applies? A. By assessing whether the ship owner's actions meet the standard of recklessness with knowledge that damage would probably result. B. By determining whether the cargo was insured for its full value before shipment. C. By considering whether the ship owner's nationality affects liability limits. D. By examining whether the ship was carrying hazardous materials. Answer A. By assessing whether the ship owner's actions meet the standard of recklessness with knowledge that damage would probably result. Explanation. Under the LMC 1976, ship owners can limit their liability for maritime claims unless their conduct was reckless, meaning conscious disregard for risk, done with knowledge that damage was likely. In the Bobel 1990, the court refused limitation where the ship owner's gross negligence contributed deadly collision. If recklessness is proven, limitation is not available. Question 25. When regulatory frameworks evolve due to changes in international shipping standards, a ship owner disputes a port state's authority to detain its vessel for substandard conditions. The ship owner argues that its flag state has exclusive jurisdiction over compliance matters. What legal principle allows port states to enforce safety and environmental standards on foreign ships? A. Port State Kanto PSC under the Paris MOU and Tokyo MOU. B. The freedom of navigation principle under UNCLOS. C. The sea within is doctrine requiring vessel safety standards. D. The doctrine of general average applying cost-sharing rules. Answer A. Port State Kanto PSC under the Paris MOU and Tokyo MOU. Explanation. Port State Kanto PSC allows nations to inspect and detain foreign vessels that fail to meet international safety and environmental regulations. Under the Paris MOU and Tokyo MOU, authorities can refuse entry to substandard ships. The United Nations Convention on the Law of the Sea, UNCLOS, grants port states jurisdiction over safety, pollution, and working conditions. In MV Erika, 1999, a SC inspection failure led to a major oil spill and legal consequences for the ship owner. Question 26. When balancing competing legal principles in maritime employment law, a foreign seafarer sues a ship owner for workplace injury under the Jones Act. The ship owner argues that the vessel is foreign flagged and the seafarer should sue in their home country. How will the court determine whether U.S. law applies? A. By analyzing the vessel's operational contacts with the U.S. and the seafarer's employment ties. B. By determining whether the ship owner is incorporated in the U.S. C. By applying the Rome Convention on contractual obligations. D. By reviewing insurance coverage for crew injuries. Answer A. By analyzing the vessel's operational contacts with the U.S. and the seafarer's employment ties. Explanation. The Jones Act protects seafarers only if significant U.S. connections exist, such as the vessel's home port or operation areas, the seafarer's employment contract location, the ship owner's business presence in the U.S. In Hellenic Lines Limited v. Roditis 1970, foreign seafarer successfully sued under the Jones Act because his employer had strong U.S. business ties. Question 27. When new economic conditions affect international trade routes, a charterer attempts to cancel a time charter, citing force majeure due to port closures. The vessel owner argues that no true force majeure event occurred. What factors will determine whether force majeure applies? A. Whether the event was unforeseeable and beyond the charterer's control. B. Whether the charter explicitly defines force majeure. C. Whether alternative ports were available for use. D. All of the above. Answer. D. All of the above. Explanation. Force majeure applies only if the event was truly unforeseeable, e.g. war, pandemic, natural disaster. The contract specifically includes force majeure. No reasonable alternatives were available. In Ocean Tramp Tankers Corp. v. Vosolfrat, 1964, the court ruled a Suez Canal closure was force majeure, excusing non-performance. Question 28. During a period of increasing cybersecurity threats in global shipping, a container line suffers a ransomware attack that disrupts cargo tracking systems. Shippers demand compensation for delayed goods while the carrier invokes a cyber risk exclusion clause. How will the court evaluate liability? A. By determining whether the cyber attack qualifies as a force majeure event. B. By examining whether the carrier took reasonable cybersecurity precautions. C. By assessing whether the exclusion clause explicitly covers cyber risks. D. All of the above. Answer. D. All of the above. Explanation. With rising cyber risks in shipping, courts consider force majeure defenses only valid for unforeseeable cyber attacks. Due diligence in implementing cybersecurity measures. Contract terms, especially in insurance policies and carriage agreements. In Maersk ransomware incident 2017, cyber attack damages were not covered by insurance due to policy exclusions. Question 29. When resolving conflicts between different sources of maritime law, a shipper argues that a carrier breached its duty under the Rotterdam rules. However, the carrier insists the Hague-Visby rules apply instead. What principle will determine which set of rules governs the dispute? A. The governing law clause in the contract. B. The country where the dispute is being litigated. C. The applicability criteria of each convention. D. All of the above. Answer: D. All of the above. Explanation: the governing legal framework depends on the contract's choice of law clause, the forum of litigation, which countries' courts hear the case, the ratification status of conventions, e.g. the U.S. applies Hague-Visby, while the Rotterdam rules are not widely adopted. In Jindalian v. Islamic Solidarity 2013, Hague-Visby was applied because the country where the dispute was litigated had not ratified Rotterdam rules. Question 30. When environmental regulations impose stricter liability on ship owners, a tanker spills oil in an exclusive economic zone (EEZ) and the coastal state demands compensation under the International Convention on Civil Liability for Oil Pollution Damage (CLC). The ship owner argues that liability should be limited under the 1992 CLC amendments. How will the court determine the extent of the ship owner's liability? Answer: D. All of the above. Explanation: under the CLC 1992 framework, a ship owner is strictly liable for oil pollution unless the pollution resulted from war, sabotage, or a third party's actions. The ship owner can prove they took all reasonable precautions. However, if recklessness or intentional misconduct is found, the owner cannot limit liability, as in the Erica case, 1999. Courts will also review insurance cover and compensation limits based on vessel size.